Welcome to Real Estate Tips. Yes, this is Wednesday, June the 17th, 2015. I'm Wayne Russell, the instructor, broker associate of Remax Southwest in Sugar Land, Texas. We're going to cover a few things today, and this is the first thing we're going to cover is the Consumer Financial Protection Bureau. The rules are closing for changing August the 1st, so you have to be prepared. You probably have several classes at title companies, but go ahead and get the exposure. And anyway, we're going to cover that. We're going to cover a FSBO, which is for sale by owner. Pre-approved for a mortgage has several advantages. Pre-qualified and pre-approved, I'm going to go over both of them. And are you giving clients correct information about credit reports? Does the seller need to disclose zoning changes? Does the landlord have to pay for a hotel room? Does the buyer get keys if the seller does a temporary lease to stay past closing? The information that I get here are from newspaper articles, magazines, and emails from different sources. Before I get started, I always like to give some information. This is an article from the Houston Chronicle that May brings slowdown in Houston home sales down 4.3%. Home prices climbed to historic highs, inventory levels improved. It's always good to check your business page on the Houston Chronicle to kind of keep you up to date what's going on. And then there's also a development in the Richmond-Rosenberg area. Officials with the City of Rosenberg, the Rosenberg Development Corporation, and Baltimore-based Paragon Outlet Partners jointly executed and approved the performance agreement that will pave the way for development and construction of a 400,000 square foot retail outlet mall in Rosenberg. Also, there's office shops in part of a project. The Houston development firm Reed King Commercial has launched a 130-acre suburban mixed-use project called Waterview Town Center. The project will include office space, shops, restaurants, medical facilities, and apartments at the northwest corner of Grand Parkway and Grand Mission. Last but not least, home sales declined again as the median prices rise. So this is all in the June 11th, Thursday, the business page of the Chronicle. Okay, we're going to start on the CFPB, which is the Consumer Financial Protection Bureau. The purpose and function of the Federal Reserve Bank of Boston. This one right here, 22nd March of 2011. I'm just going to just cover the main things, and then you can read the rest on your own. What caused the financial crisis? Dangerous products and practices greatly inflated the housing bubble. Wall Street demand for the riskiest, highest cost loans caused the dangerous lending. Federal regulations turned a blind eye to those abuses, and overly broad pre-exemption prevented states from acting. Failure of federal regulation on the next page. I'll let you read that on your own. The need for independent consumer agency. The federal regulator failures directly led to enactment of the Consumer Financial Protection Bureau, CFPB, as part of the Dodd-Frank bill. I'll let you read that rest on your own. The next one is 3 areas of regulatory work: rule writing, consumer protection supervision, and enforcement. An organic rule writing authority, preventing unfair, deceptive, or abusive acts and practices. I'll let you read the rest on your own on that. And then rule writing authority, transferred statutes, the TILA, FCRA, etc., ability to regulate or ban forced arbitration, prohibition of setting usury cap, and rule writing. I'll let you read that rest on your own. And rule writing process, traditional notice and comment with one or more requirements must convene small business panels to commit before proposing a rule. As I said, I'll let you read the rest on your own. And examination and enforcement. For consumer protection matters, CFPB will have exclusive supervisory authority to full enforcement authority over depositories, banks, etc. So I'll let you read that on your own. And CFPB rules are generally not preemptive. States can enforce CFPB rules toward national banks and thrifts. CFPB complaints function. CFPB's primary functions include collecting, investigating, and responding to consumer complaints. I'll let you read the rest on your own. And CFPB complaints functions continue to date. No announcement on how this will be implemented. 2 issues most important to consumer civil rights groups: complaint resolution, transparency. CFPB draft organization chart shows the director and just information, more information about the CFPB CFPB. And CFPB Implementation Basics, transfer date the 21st of July 2011. Substantive rulemaking authority begins on this date. I'll leave the rest on your own. It looks like to me it's currently approximately 150 employees and 700 employees expected by July. CFPB Implementation Agency Director status. No nominee yet announced for Senate confirmed director position. CFPB Implementation Rulemaking. Rules required to operationalize the Bureau. Rules mandatory under the Dodd-Frank. And the next one is congressional threats to CFPB. Some in Congress have called the repeal for CFPB or even all of Dodd-Frank. No realistic political chance that this will happen. Would not pass both houses, and President would veto it if it did. CFPB's expected impact on consumers. I'll let you read that on your own. And then this is the main thing right here. Prior to closings, you're going to have a 3-day closing. In other words, you can't get a clear to close day before closing. You're going to have to get a clear to close minimum of 3 days, maybe.
How about cash?
Cash is you don't. That's a different deal. Right. So.
That doesn't come.
Right. So, but this is on a loan. And it's 3-day closing and disclosure rules, the closing dates, and it says down at the bottom, it says if a federal holiday falls in the 3-day period, add a day for disclosure delivery. The 3-day period is measured by days and not hours, thus disclosures must be delivered 3 days before closing and not 72 hours prior to closing. Disclosures may also be delivered electronically on the disclosure's due date in compliance with e-sign requirements. So, even if you get a clear to close the day before, you probably have to get a clear to close 3 or 4 days before. And also, the rules for closing are changing on August the 1st. Why is the closing process changing? To help consumers, the CFPB, which was created by the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010, made these changes to improve the consumer's understanding and mortgage disclosures to make it easy to compare loans and to prevent surprises at the closing table. When do the changes take effect? August the 1st, 2015. And what are the changes? The most important changes for you and your clients are 2 new forms, the loan estimate and closing disclosure. This is what the closing disclosures look like, and this is what the loan estimates will be looking like, something like this. So anyway, you probably have this in previous classes, but I just wanted, this is kind of a repeat for some. There's also some information from RE/MAX, your home loan toolkit, a step-by-step guide at CFPB down in here, Consumer Financial Protection Bureau. Okay, how is the closing disclosure different from the HUD 1? A major change in the closing disclosure unbundles the closing services and separately itemizes each charge so consumers can see what they're paying for. All fees are listed alphabetically and there are no uniform line numbers. Each closing disclosure will be unique as different lenders charge different fees and may assign those fees different names, pest inspections instead of termite inspection. Who provides this closing disclosure? You can either have the lender or the closing agent, which is a title company, may provide the closing disclosures. What if the closing disclosures needs to be amended? Changes can be made to the closing disclosure as long as the corrected version is provided to the bar at least 1 business day before closing. The only exceptions are the following changes, which trigger another mandatory 3-day minimum disclosure period before closing can take place. The annual percentage rate of a loan changes more than 1%, the loan product changes, and a prepayment penalty. Do you count the closing date as part of the 3 business days? No. If the closing is on Thursday, the buyer needs a disclosure by Monday for the closing disclosure business days, means all calendar days except Sunday and legal public holidays. What if a client applies for a loan before August the 1st, but won't close until after August the 1st? If the loan application is submitted before August 1st, the current rules and disclosures apply, even if the transaction closes after August the 1st. Can the lender use the new disclosures for loan applications submitted before August the 1st? No. Are there mortgage loans that these changes don't affect? Yes. The changes do not apply to home equity lines of credit, reverse mortgages, mortgages secured by mobile homes, or dwellings unattached property, or mortgages by lenders that make fewer than 5 loans per year. What about the sellers? Do they get the closing disclosure? Sellers will receive closing disclosures no later than closing. Let's see. The new TAR form. Okay, let's just say right now you can't just call the title company and call your mortgage company and say, I need the information on the status of the loan or the status of whatever. So they're going to have a new form coming out, and then you're probably just going to have to put this in your listing package. And of course, thanks to Robert, he gave me this information. But the new TAR form preserves your access to closing docs when new CFPB rules go into effect. Starting August the 1st, the HUD-1, the truth in lending disclosures, and the good faith estimate are being replaced with new forms. As part of these changes from the Consumer Financial Protection Bureau, lenders and title companies are concerned about sharing closing documents with anyone other than the principals to the transaction unless specific permission is granted in writing. The Texas Association of Realtors created the new authorization to furnish TILA RESPA Integrated Disclosures TAR 2516, which is here. Right here, 2516. And it'll probably be in zip forms later, but that's, you have a copy of it there in case they come out late. So anyway, you might want to put this in your listing file or buyer's rep file so that.
So this is one we would need to get the buyer
or the seller to give me permission so we can talk to the mortgage company or the title company in regards to their transaction. Because if you don't have this, the title company, mortgage company just say, you know, I can't give you the information, it's confidential.
But
So
you get it anyhow at closing.
I know, but after August 1st, they're going to be tight-lipped, and you'll need this right here.
So we won't get it otherwise, like regular?
Well, I think the other thing is just protection. Yeah, Privacy Act for the
Oh,
protection.
we are the agents, what privacy?
Well,
I know,
that's
but I know.
why you get this
That's why you
signed,
get this
because they
signed.
now release.
So that you can
More
email
for
this
the
to the
agent.
title company or mortgage company saying, I need some information. Okay, sure, here it is. And-
Wow,
But
I thought
without
we
this,
were the
they won't.
agents. Okay.
Right. So anyway, it's TAR 2516, provide that written permission for lenders and title companies to deliver copies of closing disclosure documents to the principal's realtor. You can download a blank copy from texasrealestate.com, and the form will be available in zip form by July 1st. So here it is right here. Always try to be a little ahead of the game, you know, so you know, eventually you'll have it. And now, let's start on something different here. You think you have enough information on that? This is, by the way, as I repeat myself, sometimes I get this information that we discussed in class from emails, the Houston Chronicle, and magazine articles and TAR. So anyway, this is an interesting article in the Chronicle. And the reason why I'm giving you this information, I think, is because if you run across some for sale by owners and they're, you know, wanted to save the commission, say, and then you might just send them this article and might persuade them to list with you. What are the mechanics of selling a home and acting as my own selling agent? I realize that to attract buyers who generally look for a home with a realtor, we will have to give the buyer's realtor the 3% or whatever they charge. We can certainly show the home as well as the listing agent, and if needed, hire a lawyer to review documents regarding the sale. Well, this lawyer's not going to work for nothing. So might as well just go ahead and list it with me. We can certainly show the home as well as any listing agent, and if needed, hire a lawyer to review documents regarding the sale. We can do our own marketing and marketing to realtors. We appreciate any comments you may have. And this is the answer to, in this article, it says, if you have all the training and knowledge that an experienced real estate agent has, then we suggest you have nothing to lose by acting as your own selling agent, otherwise known as the for sale by owner, or FSBO. However, a caveat is in order here. It's not what you know that gets you into trouble. It's what you think you know that's not so that gets you into trouble. Be careful. This can be a complicated process leading to a complicated transaction with many required forms. It is a wise person who states, I know where my heart is, but I'd prefer to have someone else, preferably a trained surgeon, to cut on it. So anyway, if you see some FSBOs and you're driving around, you say, you know, I'm going to send him some information and send him this article, and maybe he'll list with me, you know, because he's tired of showing the property to unimproved or pre-approved buyers and pre-qualified buyers, you know, just the tire kickers. Anyway, The next one is getting approved for a mortgage has several advantages. When you're working with buyers, you want to make sure that hopefully they're pre-approved, not just pre-qualified. But anyway, when getting pre-approved for a home loan helped me buy a home? Yes, for a couple of reasons. Pre-approval is a free realty check that gives you an idea of how much you can borrow. It should be one of your first steps in buying process. The lender will look at your credit history, income, savings, and debts, and decide how much you are qualified to borrow. Pre-approval may prevent you from wasting time without shopping for something you ultimately can't buy. Yeah, I've worked with buyers before for $250, and so we're ready to make an offer, and so on out. And then, of course, the listing agent wants you to submit a pre-approval or pre-qualified letter. And so we get the letter, and you only qualify for $150. So I've already wasted my time. So try to get that information prior to going out with your buyers. Let's see here. You usually get a letter in the mail within a week or two saying if you qualify for a mortgage and how much they're willing to loan you. Note that there's a difference between pre-approval and pre-qualified. The latter is just a rough estimate of how much you can afford to borrow that's made without the lender checking any of the information you provide. Sellers will take offers from pre-approved buyers more seriously because they're more likely to get the financing they need to complete the purchase. And how does this work? You will find a standard mortgage application that asks how much you make for a list of your assets such as cash, banks, accounts, investments, and your liabilities including car loans, student loans, credit, and car debt. I'm going to let you read the rest on your own, but I'll tell your buyers, you know, let's just say they're so anxious to get furniture and go ahead and charge up their American Express or MasterCard or whatever, their plastic to buy things for their house. Well, tell them don't start buying anything until they have closed on the transaction, and then they can buy anything they want, because it could affect your credit and it could affect the purchase of your home. Are you giving clients correct information about credit reports? I got this from Texas Realtors. So it also has a legal disclaimer saying the material provided here is for informational purposes only. It's not intended, it should not be considered as legal advice for your particular matter. You should contact your attorney to obtain advice with respect to this information. Anyway, the first question is, and y'all probably get these emails, but sometimes you just say delete the emails and I'll look at it later, but here's your chance to look at it. Are you giving clients correct information about credit reports? And the first question is, one of the best pieces of advice you probably share with clients and prospects to monitor their credit reports, but are giving them accurate information. See if you answer these questions about finding and interpreting into info from credit reporting agencies. True or false, information about your checking and savings accounts is included on your credit report. According to the answer is false. Which of the following appears on your credit report? Identifying information, name, address, social security number. The question 2, the answer is all the above. Credit inquiries for the last 2 years, bankruptcy liens, judgments, and payment history. Number 3, it says true or false, a credit report doesn't include the consumer's credit score. Well, the answer to that is a free credit report doesn't include a credit score, but a consumer can purchase a score from the credit reporting agencies and scoring companies. So just wanted to, the answer should have said a free credit report. Anyway, how often can a consumer order a free copy of his or her credit report? It's B, once a year from each of the 3 reporting agencies. And number 5, true or false, if a consumer orders a credit report for himself, it will negatively affect his or her credit score, and the answer is false. So just some general information. And the next one is, does the seller need to disclose zoning changes? You know, in certain areas of town, there's zoning, and then there's restrictions. Most of the Houston area has restrictions, and so, but certain areas have zoning, and sometimes the zoning changes, and if you're buying a house in an area that, say, are going to be zoned commercial, well, then you may hold off unless you're going to convert that house to commercial. So anyway, and if you're aware of it and you're getting a listing on a house or a property that's going to have the zoning changes, you ought to try to disclose that. And find out what the zoning is, if it's going to be for high-rise apartments, or if it's going to be for strip centers or office warehousing, or whatever the zoning is. You need to know what that zoning codes mean so you can disclose that to the buyer. My seller client knows that his next-door neighbor has applied for a city to change his property zoning. Is the seller required to disclose the information to potential buyers? The seller and seller's agent are required to disclose known material facts about the property because the zoning change could be something a buyer would want to know before deciding to purchase the property. It's a good idea for the seller to disclose what he knows about the potential zoning change. You may want to inform the seller that, as a seller's agent, you are required to disclose known material facts about the property. The next one is, does a landlord have to pay for a hotel room? In other words, I manage a couple of properties, and anyway, if this happens, if you're a friend of yours, say you're managing some property for them, or if a friend of yours says, well, you know, what happens in this scenario? So a tenant notified me yesterday that his water heater stopped working. A repairman came to the property today, but the water heater requires a part that won't arrive until tomorrow. The tenant is upset and wants the landlord to pay for a hotel room for tonight. Is the landlord obligated to do this? The answer is no. Nothing in Texas Property Code and TAR Residential Lease 2001 requires the landlord to put the tenant in a hotel room where repairs are being made. A landlord isn't obligated to pay alternative housing for a tenant based on the need to repair, even if that repair relates to a condition that could be construed as a material affecting the physical health and safety of the ordinary tenant. If a landlord fails to make a diligent effort to remedy a condition that materially affects the physical health and safety of the ordinary tenant, the tenant remedies are found in section 192.056 of the Texas Property Code. Next one, does the buyer get the keys if the seller does a temporary residential lease to stay past closing? A lot of times the owners today they don't have a place to go. Or let's just say they're in between. Let's say they're building a new home. And that home is not ready for another 30 days or 60 days, and they don't want to move twice. So sometimes the sellers, it's all negotiations, will sign a temporary residential lease. And a temporary residential lease is after closing, and it's so much a day. And what's the fair amount? Well, you know, everything's negotiable. I'd say if it's a $100,000 sale, the lease back to take care of the principal and interest, taxes and insurance, and the inconvenience of not occupying the property at closing, I usually compute pretty close to 1% per month. But you know, if it gets up to $1 million, you know, everything is negotiable. Anyway, as the question is, does the buyer get keys if the seller does a temporary lease to stay past closing? My seller is closing next week, but will stay in the property for 30 days after closing until under a temporary lease. Does the buyer still get a set of keys at closing? And the answer is yes. The seller's temporary residential lease, TAR 1910, TREC 15-5, states that the tenant will provide the landlord door keys and access codes. Let's just say they're in a gated area. So he or she may enter the property at reasonable times to inspect it during the term of the lease or to otherwise access it as allowed by lease. However, the buyer cannot occupy the property until the termination date stated in the seller's lease unless it's terminated earlier by the reason of other provisions. And I pulled up the seller's temporary residential lease, and it says in item 12, it says, landlord may enter at reasonable times to inspect the property. Tenant shall provide landlord door keys and access codes to allow access to the property during the term of the lease. You know, a lot of times you prepare these temporary residential leases, and sometimes you don't read all that's in there, and you say, oh my gosh, what do I do? So I just wanted to bring it to your attention on providing access and door keys to the, really to the landlord, because he is the landlord in this scenario. This is going to be a short session, but do y'all have any questions? I want to appreciate y'all coming on a rainy day, and this is the first session that we're going to have that's hopefully going to be on YouTube soon. So anyway, thanks a lot for everybody coming, and y'all have a great day.
Thank you.
And it's the first session we've done during a hurricane.
That's right. Well, actually, it was a storm. What is it? The tropical storm.
Tropical storm.
There you
yes,
go.
Close.
Depression.
There you go.